The law of the sea is a complex and dynamic body of international law that governs the use and conservation of the world's oceans and their resources. It is a critical component of global governance, as it provides a legal framework for the use of the world's oceans and helps to ensure their peaceful and sustainable use. The law of the sea is constantly evolving, reflecting changes in the global political and economic landscape, as well as advances in marine science and technology. The law of the sea has its roots in customary international law, which reflects the long-standing practices and customs of states in their use of the oceans. Over time, these practices and customs have been codified into treaty law. And today, the most comprehensive and widely recognized treaty governing the law of the sea is the United Nations Convention on the Law of the Sea, which was adopted in 1982 and entered into force in 1994. UNCLOS provides a comprehensive framework for the use and protection of the world's oceans and their resources. It establishes the rights and duties of coastal states, the rights of navigation, the delimitation of maritime boundaries, and the regulation of marine scientific research. It also provides for the conservation of the marine environment, including measures to protect and preserve the diversity of marine life and ecosystems, as well as to prevent and control marine pollution. One of the key provisions of UNCLOS is the definition of the maritime zones that coastal states can claim. Coastal states have sovereignty over the waters and resources within 12 nautical miles of their coast, known as the territorial sea. Beyond the territorial sea, coastal states have the right to establish an exclusive economic zone extending up to 200 nautical miles from their coast. Within the EEZ, coastal states have exclusive rights to explore, exploit, conserve, and manage the natural resources, including living and non-living resources, in the water column and on and under the seabed. UNCLOS also provides for the rights of navigation and overflight, including the rights of all ships, whether military or civilian, to sail freely and peacefully through the territorial sea, the EEZ, and on the high seas. The high seas are those areas of the oceans that are not subject to the sovereignty of any state, and are considered to be the common heritage of mankind. UNCLOS provides for the freedom of the high seas, which includes the right of ships to engage in commerce, to fish, and to carry out scientific research, among other activities. Another important aspect of the law of the sea is the delimitation of maritime boundaries, which involves determining the limits of coastal states' maritime zones and the extent of their rights and jurisdiction over the waters and resources of the oceans. This can be a complex and sensitive issue, as it often involves conflicting claims by states over the same waters and resources. UNCLOS provides for the peaceful resolution of disputes relating to maritime boundaries, and states are encouraged to settle their disputes through negotiation, mediation, and other peaceful means. In conclusion, the law of the sea is a critical component of global governance, as it provides a legal framework for the use of the world's oceans and helps to ensure their peaceful and sustainable use. UNCLOS is widely recognized as the cornerstone of the law of the sea, and its provisions have been ratified by more than 160 states. The law of the sea continues to evolve, reflecting changes in the global political and economic landscape, as well as advances in marine science and technology. The effective implementation and enforcement of the law of the sea is essential to promoting the sustainable use and conservation of the world's oceans and their resources, and to ensuring the stability and security of the global ocean community.